Hello everyone, welcome to Court with Krissy. By the way this defendant is about to react, you would think he was told his dog died, but nope. He finds out he's facing felony charges from meth. Probably the pants weren't his. But the best part? Just watching Judge Wiggins listen to it all go down. I hope you like it. Court with Krissy is now in session.
Okay. Are you prepared to be sentenced on that file now? I need the prosecutor.
Yeah.
We need to hold off until we can get a prosecutor up here. While we're waiting for a prosecutor on that file, I'm going to arraign you on the new file I have for you. This is 251254 FY, the people of the state of Michigan versus Frank Patrick Williams. We're here for an arraignment. Mr. Williams, are you still homeless?
Yes.
Do you have a good mailing address though?
No.
You have a phone number?
I do not.
You have an email address?
No.
And it's my understanding you are not requesting to speak with the public defender today, is that correct?
Yes. That's when I get this stuff over with, man.
Sir, I have a complaint that alleges that on or about April 9th, 2025, here in the city of Cadillac, Wexford County, you did in count number 1 possess the controlled substance methamphetamine. That is a 10-year felony and or a fine of $15,000. The prosecution.
Wait. This is when I just got picked up this time?
That's what I have in front of me. Do you want to speak with the public defender?
Yeah.
Okay.
Oh my God.
Are you able to get into a breakout room, Mr. Hartel?
Right there. They did not say that they charged me.
Public defender's gonna come over, okay? No, sit down, like, sit down. Let me get somebody down here.
49 is on scene.
Pray. Just found out he's getting tried for some other stuff.
Frank, let's go.
Public defender, he still has to be right.
Oh, we're still gonna, okay, right?
Corrections, you need to take him out for a couple minutes.
I'm sorry?
You need to take him out for a couple of minutes.
I think so.
Okay, go ahead and do that.
Okay, we're good.
Let's go.
Let's get you through this, okay?
Come on. Yeah.
Are they still on?
Are you able to hear me, Can you see me?
Yeah.
Okay. Are you calmed down enough that you can speak with the public defender?
Yeah.
Okay, I'll put you both in a breakout room.
We'll have to step out.
Mr. Williams, are you ready?
Yeah.
So I want to back up before we go into the arraignment. Knowing now what you know, do you still wish to represent yourself on the B&E file, or do you want the court to
Yeah.
appoint an attorney? You still want to represent yourself on that one? Okay,
Yeah.
defendant's nodding his head yes for the record. So I'm going to pick up where we left off on the felony complaint on the new arraignment in 25-1254 FY. You, that on or about April 9th, 2025 in the city of Cadillac in Wexford County, Michigan, it's alleged that you did possess methamphetamine, which is a 10-year felony and or a fine of $15,000. The prosecution has elected to charge you with a second subsequent offense notice, which means that you have a prior conviction for controlled substances, in specific possession of methamphetamine. That makes that 10-year a 20-year felony and or a fine of $30,000. In the alternative, they have elected to charge you as a habitual fourth offender, which means that you have at least 3 prior either completed or attempted felonies in your past. That would make that 10-year felony a life offense. Do you understand the charges and the potential penalties?
Yeah.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you in court. You have the right to appointment of an attorney for any questioning that you consent to, and you also have the right to stop any questioning that you consent to. You also have the right to be represented by an attorney at all phases of this process, and if you're not able to afford an attorney, one will be appointed to represent you. Do you understand that?
Yes.
You could also be required to repay a portion of that appointed attorney fee. Do you understand that?
Yeah.
Do you plan to hire an attorney, or do you want the court to appoint an attorney for you?
Yeah, I'm gonna appoint, I need one appointed.
And what's your current source of income?
I have none.
The court will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. The preliminary examination is a hearing that's held here in the district court within 21 days from today's date. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case will be dismissed. If they are able to do that, you'll be bound over to stand trial in circuit court. Prior to the preliminary examination, a probable cause conference will be held. That is an opportunity for the attorneys to see if there's a way to resolve the case short of going down the trial track. Do you understand that?
Yeah.
You also have a right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. In counsel in 2014, I show an attempted resist and obstruct. In 15, an attempted resist and obstruct. In 18, a retail fraud third. In 18, a domestic violence. In 20, a disorderly drunk. In 22, possession of methamphetamine and obstruction of justice. He's on bond for us for the B&E file in which he represents himself, in which he did not appear for sentencing. And he has 2 failed to appears out of the 50th District Court. Mr. Hartel, anything regarding bond?
Yes, Your Honor. I do realize, of course, to address the elephant in the room, it is a bit of an uphill battle when a defendant recently had a failure to appear. But just so the court is aware, during my brief discussions with him, he is feeling the weight of the situation. I'm sure the court noticed some of that earlier as well. He has advised me that if at all possible for the court to overcome the burden and grant a PR bond, as much as that is to happen in the situation, he would obey all bond conditions. And the reason I say PR instead of low money bond is he advised me that being unemployed with no source of income, even a single dollar, he could not post, just so the court is aware. Thank you.
Mr. Carnes?
Thank you, Your Honor. The people are concerned about fail to appear based on the appearance of the last file. I do think a cash bond is appropriate as well.
But when I look at the bond setting factors in the court rules, some of the things I'm supposed to take into consideration is the defendant's prior convictions, which we've already gone through, a record of appearance or fail to appear. We know that he's got 2 failed appears out of the 50th District Court, which he told us last time was because he's unable to get down there. And then we also have a fail to appear in a case in which he's before this court. I also must look at history of substance abuse or addiction. It's alleged that he was possessing methamphetamine in this case, but we also have the 22 possession of meth conviction. The defendant's mental condition or reputation for dangerousness or character. Well, I have nothing on this. My own observations that I saw today. While I understand that this was a shock, I do have some concern for the defendant's mental condition. It's also my understanding, based on my reading of the probable cause affidavit in this case, that there is an approximately 20-inch machete in his possession as well. Seriousness of the offense charged, it is potentially a life offense if he were convicted of the habitual 4th offense noted. The defendant has the ability to post a money bond at this time due to unemployment. There are no responsible members of the community to step up for him. Last time he was in here, he was told that he'd go to his mother's house, but that does not appear to be the same today. Ties to the community, relationships, and length of residence. I know he is a longtime resident of Wexford County, as we've had dealings with him in the past, and then risk of non-appearance and danger to the public. As I said, we've already had the non-appearance and then the danger to the public. As I had indicated, the possession of the machete is concerning. I do find that the defendant is both a flight risk and a threat to the community. I am taking into account his inability to post a monetary bond, but I do believe one is appropriate. I'm going to set bond at $25,000 cash or surety with the following conditions: that the defendant appear as ordered, keep his contact information current, not leave the state without permission, and commit no new crimes. In addition, he is not to possess any drugs or recreational marijuana, and he'll be subject to random testing. I'm also going to order that the defendant not engage in any threatening, intimidating, or harassing behavior, and he not be in possession or purchase of a firearm or weapon. Mr. Carnes, anything else in a pretrial release order?
No, Your Honor, thank you.
Mr. Hartel?
Your Honor, would it be possible for an immediate release to treatment, as the court did note he has a history of substance abuse issues?
I'm not going to order that today, but I won't foreclose the possibility of you filing a motion in the future.
Thank you, Your Honor.
Now moving on to case number 25-10057, I'm sorry, 1057 SM. That's the case in which the defendant failed to appear and has already indicated that he wants to go into sentencing today. And he's also indicated twice now that he wishes to continue to represent himself on this case. Mr. Carnes, I don't remember if you were here or not, but at arraignment, the defendant did enter a guilty plea as charged.
I was here that day, Your Honor, thank you.
Any allocution? Mr. Carnes?
Yes, Your Honor, thank you. This was a incident where defendant and 2 other people broke into an abandoned house.
Was it an abandoned house or the railroad station?
Thank you, Your Honor. I shouldn't have said house, an abandoned building. It might be the railroad station. I don't know the area. But the owner was contacted. They did not have permission. I'm sorry, a friend of the owner's was contacted and did not believe that permission would be there. I think a jail sentence of 15 days is appropriate here. Thank you.
Is there any restitution requested?
There's no restitution requested, Your Honor. Thank you.
Mr. Williams, is there anything you'd like to say before sentencing?
No,
See up to 2 days credit now.
Yeah,
Well, I remember at the arraignment and when you entered the plea in this case, you had indicated that the reason you had broke into the building was because that you were homeless
Yeah, I'm gonna be here for a long time, so just max me out.
and due to weather as well. I don't believe that there's a need for probation in this case, given the case that we just arraigned Mr. Williams on. I'm going to order that there is a $75 crime victims' rights fee, a $50 state minimum fee, $150 fine, $150 court costs. Going to order 10 days jail with 2 days credit. Mr. Williams, I must inform you that if any unpaid balance remains after 56 days, there is a 20% penalty that will be assessed to your file. Do you understand that?
Yeah,
Okay. Do you have any questions for me? Okay.
no.
Thank you, Jail.
Thank you, Your Honor.